Good morning to all of my fellow Bahamians. I hope you are all faring well. Today I would like to read from a statement that was made by the Right Honourable Prime Minister Minnis when he was the Leader of the Opposition. It is a statement that was issued on August 6, 2014, and I am going to read his words for you so that it can place into context some of what we have spoken to in the past press release. And I quote, "It is now 3 weeks since it was reported that the Prime Minister demanded the resignation of Renward Wells. Wells has blatantly refused to resign, and the Prime Minister is obviously not man enough to fire him. If this situation were not so serious, it would be laughable, but this is no laughing matter. Where a Prime Minister appoints any person, he also has the right to disappoint that person. This is an important parliamentary convention that underpins our democratic tradition. No appointed politician has a right to tell a Prime Minister that he will not resign when asked to do so. Yet last week, Wells told the nation that he would not resign. There has been a clear breach of the conventions that have always governed operations of cabinet governance and which have thus far underpinned the system of parliamentary democracy. The fundamental principle is accountability to Parliament and the people for the wrongdoing of elected officials. If the governing party is not going to hold itself accountable for its actions, then we are left only with a parliamentary dictatorship of the majority. This is a sad and deeply alarming state of affairs. Wells has clearly acted without authority. He has committed the Bahamian people to a letter of intent, which will subject the Bahamian taxpayer to ascertainable financial penalties that could amount to millions of dollars if certain conditions are not met. All hard-working Bahamian taxpayers will pay for this egregious act if this government does not move quickly. I am reminding everyone that these are the words of our Right Honourable Prime Minister in his then capacity as Leader of the Opposition, and the words that he used ring as true today as when he first uttered them. I continue. The Bahamian people are right to have the deepest suspicions about the apparent lack of integrity and accountability of those persons who hold the highest offices in this Christie government. This Wells affair is only the latest of many such acts, including gaming referendum, Renew Bahamas, Noel Prosequi, and privatization of garbage trucks. The Bahamian people are right to ask why the Prime Minister is either afraid or unwilling to act. The latest example of this comedy of malfeasance in a public office was the publication last week and the apparent reliance by the Christie government on a so-called opinion by the Permanent Secretary. The impression the government is trying to create is of their having made some kind of genuine inquiry by asking for the views of the Permanent Secretary. This is a deceptive strategy, and the Christie government ought not to make the Permanent Secretary, who is a long-standing public servant, a scapegoat in this matter. If the Christie-led government seriously wanted to assess the legal validity of the letter of intent, why did they not ask the Attorney General? What we want to know is, what is the legal opinion of the Attorney General, who we assume is legally qualified to give such an opinion, to give a legal opinion, I beg your pardon. The government has either not sought or not disclosed to the public any such advice from the Attorney General. Today I produce to you and to the Bahamian people a copy of a document which appears to be the full letter of intent signed by Parliamentary Secretary Renward Wells for and on behalf of BEC and on behalf of the government of the Commonwealth of the Bahamas. The agreement ends with a general indemnity clause, Clause 8, which states that if for any reason the project does not proceed, then each party will bear their own expenses and opportunity costs and will indemnify the other party from any claims whatsoever in this regard. A close reading of this clause shows that the document is ambiguous as to the quantum of liability that Mr. Wells may have subjected the Bahamian taxpayer to, and the conditions under which such financial liability will be assessed. On the face and by the very terms of these two clauses of the letter of intent, Mr. Renward Wells has, in fact, signed an agreement which binds the government of the Bahamas to a contingent liability which could well exceed $40 million if the proposed project does, in fact, proceed as set out in Clause 6, but then fails to receive NEC approval, and in the event that the project developer has fully complied with the production of the 3 FELS stipulated in the agreement. In short, if the project proceeds and the developer complies, but the government breaks the deal, then the government is liable to pay compensation. In such a case where the project proceeds but government approval is not granted, the government by this document may have incurred a contingent liability of up to the amount of the borrowing by the developer if the government fails to approve the signing of a power purchase agreement by BEC. There is no question that, should the project proceed, as envisaged in Clause 6 of the agreement, then the government would be bound to approve the power purchase agreement or pay compensation in an undetermined amount. On its face, once the developer proceeds, there appears to be a binding agreement which could tie the hands of the government. Moreover, if the money was borrowed from a source outside the Bahamas, the government could find itself fighting a legal battle in a foreign court, where punitive damages could be assessed far in excess of the $40 million that Stellar may have borrowed. The signing of such a letter of intent is far more serious than was previously thought. Mr. Wells has not just interfered with the portfolio responsibility of another government ministry. He has gone much further and has signed a document which binds the Bahamas government itself and makes the government liable to pay some amount of contingent compensation to a foreign investor if the government should fail to approve the execution of the power purchase agreement by BEC. Now, these comments that I've just made are the statements of our Right Honourable Prime Minister, the Honourable Hubert Minnis, in his capacity as then Leader of the Opposition. And I believe fervently that they ring as true today, in 2020, May 20th, that is, as they did on August 6, 2014, when he initially uttered these phrases. We cannot, in a modern sense, in this modern world that we live in, ignore such clear and stated positions that have been taken by what is now an individual who is now the leader of our country. He rightly, at that time, after having, I'm sure, received advice from various counsel associated with the opposition, would have made a true and correct statement as it concerns the legality and the contractual enforceability of this agreement between the clients that I represent and the Bahamas government of the past administration. The issue is now that we are, as I have stated before, obliged to go through multiple rounds of litigation for a matter which in truth would be in the benefit of our country to resolve in an amicable sense. And by that I mean the potential to move ahead to a resolution of the claims and to actual fruition of the initially envisaged project, something which I'm sure would benefit the populace in the entire country. It's something which I think a lot of us should be concerned about. It strikes at the very heart of the environmental viability of our country, and we owe a duty not only to ourselves, but also to our children and our grandchildren to do everything within our power to ensure that we leave this world in a better condition for them than that in which we found it. And so, again, the struggle against our government continues, and we will remain steadfast in our resolve